So can a criminal defense lawyer get a sentence reduced after a defendant has been sentenced? The short answer is yes, it can happen, but you need to be aware there's a short time frame to file what we call a Rule 35 motion under West Virginia law to get you back into court to ask a judge to reconsider the sentence. The Rule 35 motion has to be filed within 120 days of your sentencing. So you've only got 4 months. So if you're considering advocating in that direction, you need to move quickly. Also, we do plenty of Rule 35s. I'm doing one right now that I'll be filing within a day or two. And it's important to know that for me to go into court on a motion to lower or reduce a sentence, I need to have a new fact. It doesn't do you any good to go back into the court and say to the judge who already considered and handed down your sentence, say, hey, judge, I want you to do it over. I don't like the result. Judges don't really want to hear that. They will listen, however, to a new fact. If I can go in and say, well, this circumstance is now different from where it was, and perhaps the previous attorney didn't effectively identify this very important fact for the court's consideration of the sentence. Those are good cases when I can go in and get some success and get a sentence reduced. So if you are in need of a sentence reduction after a sentence has already been handed down and you need to get a qualified attorney to do that, yes, we can do that. You need to call me quickly, though, because, again, there's a deadline that runs, and it's 120 days. If I get outside the deadline, is there a way for me to get back into court anyway? Yes, there are ways to do it. It's not preferable, but it's possible. So I wouldn't say never ask for a Rule 35, but it should be, if it's not within the 4 months, it should be very quickly outside that frame.